Good afternoon, and thank you for clicking on the link to this receivership introductory presentation on receivership in Maryland. I'm here today with Paul Sweeney. Paul Sweeney's, for my money, the best insolvency and creditor and debtor rights lawyer in Maryland. I've worked with him before. He's the managing member of Yumkas, Vidmar, Sweeney, and Mulrenin, and has over 30 years experience in commercial receivership, complex Chapter 11 bankruptcy, and commercial litigation. Mr. Sweeney's also served as a bankruptcy trustee for the Office of the United States Trustee. He's the past president of the Maryland Bankruptcy Bar Association and a past member of its board of directors. For a number of reasons, Mr. Sweeney's uniformly recognized as preeminent in his field by Martindale-Hubbell, Best Lawyers in America, and by those who know him and have worked with him. A link to Mr. Sweeney's biography can be found at the CRA website at the Maryland tab. So I want to thank you, Paul, for being with us today and giving us a primer on receivership in Maryland.
Thank you, Eric.
So just to kick off, could you tell us from a high-level perspective, how does commercial receivership work in Maryland?
Thank you. We have the benefit in Maryland of a recently enacted statute that improved and increased the powers of receivership law in the state of Maryland. It's found in the commercial law article. Its companion is also referenced as the assignment for the benefit of creditors, both of which are state court insolvency proceedings. So in the past, I think it was October of 2018, when the new law was passed by the Maryland legislature, they've since also adopted Maryland rules to follow along with the statute. My firm was one of the first firms to file receivership, and in the county court that we filed the case in, because it was a new case, we did prepare a complaint. It was based on deadlock. We did not want to deal with the expense of a bankruptcy and a bankruptcy trustee. It was a single asset case. There are some related litigation issues that need to be resolved by the receiver. And we thought going to the state court was a more economical way to proceed. And it also did not require the oversight of the Office of the United States Trustee. It just requires the oversight of the state court judge. So we prepared a complaint, and then we prepared related pleadings to tee up the issue, because in my view, and in my experience, teeing up a motion as an emergency or a temporary restraining order, if you have the grounds, gets you the attention of the court so that you're not languishing. And again, bankruptcy, sometimes you languish. In state court, I've been successful in the last few cases I've filed in receivership in getting the court's attention. The receiver is a quasi-judicial authority, and whether I serve as the receiver or whether I am counsel to the receiver, the state courts have been responsive. Related to the complaint, you do need to file a motion for appointment, and then in Maryland, we have the benefit of the rules that tell you the sort of disclosures that you need to follow. The new statute was written in mind of mirroring some of the bankruptcy provisions of giving disclosure, list of connections, so that when the court appoints the receiver and appoints legal counsel, the court has the benefit of seeing those credentials and seeing what connections exist. So most of those first day pleadings can be filed either immediately after you get the receiver appointed, or you can file it with the package, because once you get the judge's attention, you want to get as many orders entered as possible. So motion to appoint receiver, accompanying legal brief on why a receiver is appointed, and then the various lines filing related affidavits in support. Then you have your applications to employ, which some of our listeners may be able to mirror on the bankruptcy format. And then just requesting that hearing and trying to get an emergency hearing in front of the judge, or scheduling with notice to the other side an opportunity for hearing.
So you've mentioned something that I think is critical in a lot of receivership cases, and that's the need for speed, I suppose. Um, Assets are getting wasted, money's disappearing, maybe that there's a building with a problem. And that sometimes in some places, I don't know how Maryland works, butts up against due process. What kind of notice do you have to give, and to whom does that notice have to go to start a receivership case off right?
Well, a lot of the rules of notice are critical when you approach the judges. Obviously, you're asking about, because they do want to be careful about ex parte orders unless you have verified facts that support a more expedited clandestine approach to getting appointed a receiver, and where there's theft, fraud, embezzlement, danger to the public. I've been successful in years past in getting these on a ex parte basis, but the more common practice that I'm following now is reflected in the rules. And I'll use deadlock as an example. You look at the bylaws and you determine shareholder agreements and operative corporate documents that control the behavior. And to the extent that you announce a meeting, you declare a meeting. And if there's deadlock, there's deadlock. That's a very simple example. You document the deadlock, and then you have an affidavit from whoever's going to petition the court to say, we've got deadlock. The statute refers to deadlock, and we've given adequate notice. And I think, given the strength of the receivership and not wanting to waste anybody's time, I serve it on the other side. And I certificate the service, and I explain to the court, we're not hiding anything. In fact, the process is so clear in many respects. By all means, schedule a hearing, let the other side come in and refute this. And in the recent cases I filed since the new statute, there's been an inability to push back, that the grounds are so clear that there is a perfunctory hearing. Generally, it doesn't last very long. But if you need to put forth your proof, you bring your witnesses and your exhibits, and the other side can cross-examine. The other side can object. The other side can do it without filing a pleading if we're moving very, very fast. So in my view, the due process, and you can, by analogy, look at the bankruptcy rules or the federal rules of civil procedure 65, excuse me, tells you the sort of notice you should give. So I kind of follow that rule as a guidepost, because I don't want to waste the court's time. And if you give notice to the other side, it in the end is better for all, to avoid appeals and other difficulties.
Your appointment orders, there's a broad range. Now, if you have an elaborate statute, sometimes it means your appointment order can be more general, sometimes not. In my experience, we used some very, very explicit and therefore lengthy appointment orders. How is the Maryland practice in terms of the appointment order? What does it look like?
I agree with you that the more detailed the appointment order in the very beginning, while you have the court's attention, I'm a big fan of that. So having the details spelled out of what the receiver can and cannot do in terms of retention and payment of professionals, authority to transact business, authority to engage in sales. One of the benefits in Maryland, quick segue, is the ability to dispose of property and sell it, which again mirrors the bankruptcy process. So having a robust order, I think, is critical to helping you later on. And we've developed a very lengthy order. And then when you have the judge's attention, you can go through those provisions. If there's any heartburn, you could always file supplementary requests for authority.
So if you go through this process, you get your appointment order, whether it's litigated or not, the receiver's now in place, the receiver's vested with property, whatever it may be. There are other stakeholders. Do those other stakeholders, maybe they're employees, maybe they're trade creditors, whatever, do they get notice that the receivership is now pending? And are they constrained to proceed against this particular debtor in the receivership court, or can they go file a lawsuit somewhere else if they choose?
Great point. Again, mirroring the bankruptcy code and rules, in Maryland, they have codified an automatic stay. They have codified notice to creditors and the filings of proofs of claim. And originally, assignments for the benefit of creditors, ABCs, and receiverships had very limited notice. And as a quasi-judicial authority, the court just relied on the receiver to properly administer the property. Now there is notice under the Maryland rules. And one of the things that's developed with COVID is getting orders that explain service or limit service and provide for electronic service. I was finding that with less office staff, having the ability to finalize a pleading, file it, and then email it to everyone, and to send a notice to all creditors saying, please register your email address. And I am glad to give you notice of anything. You know, there's no secrets here, to the extent that it's the push of a button on an email service. That's something that I've grown quite fond of, both in state court insolvency and in bankruptcy cases.
And these creditors who get notice, how can they participate in the case? Do they have to intervene, or is there something less than formal intervention that allows them to come in and be heard on whatever issue?
Again, there were previous limitations on who can appear and be heard. In the cases that I've been working on, usually the direct adversary in the case of a deadlock has obvious standing to participate. And I have found that the courts have adopted a fairly liberal standard of allowing people the opportunity to object and be heard. So the issue really hasn't come up to fight somebody on standing. And maybe that's just philosophically on my personal view, unless it was a very bizarre circumstance. File your objection, let the court deal with it. And whether or not you've got the standing, I'll raise that issue as needed, but the court's generally going to listen. You've got state courts. They're not the specialty courts that you have in bankruptcy court, where they really know insolvency. You're dealing with judges of different background and experience. Some are business lawyers, some are prosecutors, some are states and trust lawyers and never heard receivership. And when you say ABC, they wonder what comes next. So it's you've got to take your judges as you find them. And with a new statute, they've been very receptive, especially where you come in well prepared and you give them a brief that explains the circumstances. And it's not just receivership law. If it's deadlock, if it's embezzlement, if it's fraud, if it's fraudulent conveyances, citing to the commercial law article, the rules and the relevant statutes before you even step into court is critically important. Have good, strong papers that let the judge know that you're comfortable in this specialized area of the law and you're willing to discuss, dare I say, educate the judge and make the judge's job easier.
Yep. So you mentioned earlier sales, which is a big topic in now. There's real estate sales. There's other types of sales. Can you sell property free and clear in Maryland? And if it's real property, will the title carriers give you coverage where there's a receiver's deed that is the conveying deed?
I am working on a couple of sales currently, and I had a sale in one of the receiverships that did not proceed, but the court did sign an order selling free and clear. And in that instance, it really involved a deadlock, and it was free and clear of the claims of ownership, which is exactly what the statute was designed to do, is to facilitate a business-like liquidation rather than resorting to the chaos that would otherwise exist without a uniform set of insolvency laws. So as part of the Maryland statute, again, mirroring the Bankruptcy Code Section 363, we're taking advantage of that. And we are working on a couple of sales currently. As I said, one sale that was approved on that basis. And I have confidence based on the title work that we received. We were positioned to close, and then there was a default. The title work was prepared to ensure title and to allow the receiver's deed to be recorded. And when you think about it, in addition to the title work and getting the title policy, getting a strong order from the court. You have a circuit court order that then can be recorded among the land records in that particular jurisdiction of Maryland. It gives comfort. And now that we've worked through it, one deal with a title insurance company, we're a little more sensitive to their concerns. And you can build in, before you even file that motion, whatever supplementary information. And again, back to your notice point, Eric, making sure that affected parties have good and valid notice. Mirroring, again, the foreclosure statute. What would you do in a foreclosure if you were going to sell? And then mirroring that good service to give the court comfort that you're not doing something that the court will regret later on. I think that's the best advice I can give in a circumstance like that. So,
are there in Maryland different types of receivers? And by that, I mean, you have liquidating, you have operating companies, you have something that's just a straight apartment building or hotel or piece of real estate. Are there formally kind of defined different types of receivers? And if not, are receivers in Maryland capable of stepping into an operating company circumstance and administering all the things that go along with the operation of a company?
The answer is yes, yes, and yes. What you have is the traditional form of equity receivership that has been developed over decades and the past couple hundred years, where an equity receiver is placed into control under various circumstances. So that's always existed, but there was no clear path. And what Maryland has adopted gives a clearer path for equity receivers to step into those situations and have the power to operate, engage in business, make payroll. Then usually you're going to dispose of those assets. Receivership can be a long-term endeavor, but the idea is there's something wrong, fix what's wrong, and either cure the issues and return it back out of the receivership or sell it. So a lot of these things wind up in a sales structure. The other type of receiver is traditionally found under real estate law, where there's an entitlement of a secured lender to appoint a receiver to administer the real property, collect the rents, and for the benefit of the lender pending a foreclosure. So the option was a temporary holding pattern on a typical receivership, real estate receivership, where the receiver is protecting and preserving the property, and then a foreclosure would then extinguish the receivership, dispose of the real property. What with Maryland developing the statute, instead of going to foreclosure, you have the ability, like I'm doing now on one of my receiverships, marketing the property for sale, just in an arm's length exchange, hiring brokers, pursuing those sales opportunities, which is not as a distressed sale, if you will. It's a more leisurely process to maximize value for all creditors.
Is that process that you just mentioned something that's statutory, or do you kind of create bid procedures, or do you just market and sell and come to the judge and say, here's what we came up with?
That's the difficulty in what we do. Not everything is written down. It takes years to really understand the process and the justification for the process. As you mentioned, should we have some bid procedures? Should we have an organized sale process, or am I just going to employ a broker? It really depends on the facts and circumstances of the case. And then to the extent that we, again, borrow from our bankruptcy experience in how things are disposed of in bankruptcy, if it fits, by analogy, you argue to the court that this is a sensible way for an insolvency situation or a receivership or ABC situation to resolve itself. And with that support, we've had tremendous luck having the court approve various actions. A slight segue, Eric, is what do you do when you settle? You settle a dispute, litigation, claims, and some of those rules just are not written down. So if it goes beyond the appointing order, again, as you mentioned in the beginning, very critical to have a good, strong order, you may need to go to the court and ask for permission to settle things. And that again mirrors the bankruptcy process and the fiduciary duties of the receiver or the assignee, and their authority to transact business is sometimes limited. So sometimes you have to make up those pleadings based on practical experience, and sadly, it's not all written down. And in Maryland, those rules are not as robust as you find in the United States Bankruptcy Code and the federal and the rules of bankruptcy procedure. So you do need to borrow at times from that experience.
Well, Paul, this has been tremendously helpful, and I know folks who watch this are going to come away with a greater understanding and probably a lot of questions as well. But I very much appreciate you taking time to give us this overview of receivership in Maryland. And I'm sure for follow-up questions, we're going to, if with your permission, put a link to your website and to your bio on the CRA website. If anyone has follow-up questions, I would, if you don't mind, encourage them to reach out to you with any Maryland receivership questions or help that they may need. So thank you so much for taking the time.
My pleasure. Glad to help, glad to answer questions or to consult as needed.
Great.